I have been insulted before. That comes with the job. Angry litigants have called me unfair, biased, stubborn, and worse. But one afternoon, a woman stood in my courtroom, looked directly at the bench, and called me lazy. Not mistaken. Not strict. Lazy. What happened next transformed an ordinary civil dispute into one of the most memorable courtroom moments of my career. And by the time it was over, the entire room understood why experience can be a dangerous thing to underestimate. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. My name is Judge Judith Harper. Over the years, I learned that confidence can be useful, but unchecked confidence often becomes arrogance. And arrogance has a way of creating its own problems. The case involved a homeowner named Karen Dawson, 48 years old, highly educated, extremely articulate, and completely convinced she was the smartest person in every room she entered. The defendant was a local contractor named Michael Turner, a quiet man with nearly 20 years of experience renovating residential properties. Karen had sued him over a remodeling project involving her kitchen and dining room. According to her lawsuit, Michael had failed to complete work on schedule, overcharged her, and ignored multiple requests for corrections. At first glance, the dispute appeared straightforward. Construction disagreements are common, schedules slip. Costs increase, expectations clash. But from the moment Karen entered my courtroom, I sensed this case would be different. She carried herself less like a plaintiff seeking justice and more like someone preparing to deliver a lecture. She spoke before being addressed, corrected attorneys during routine introductions, and repeatedly interrupted proceedings to explain what she believed everyone else had misunderstood. Years on the bench teach you to pay attention to patterns. 1 interruption means little, 5 interruptions mean something, 10 interruptions tell a story. The jury noticed it too. I could see several members exchanging glances as Karen repeatedly inserted herself into conversations that did not involve her. Meanwhile, Michael Turner sat quietly reviewing documents, contracts, invoices, inspection reports, photographs. Stacks of records. Unlike Karen, he seemed focused entirely on evidence. That difference immediately caught my attention. As testimony began, Karen presented herself as the victim of incompetence. She described delays, mistakes, frustration. Broken promises. Her story sounded compelling. In fact, for a while, many people in the courtroom appeared sympathetic. Then something happened. Michael's attorney introduced project records showing that many of the delays resulted from change requests submitted by Karen herself, additional cabinets, custom countertops, lighting modifications, flouting upgrades. The project had expanded repeatedly. As the evidence appeared on the screen, Karen became visibly irritated. Not nervous, irritated. There is an important distinction. Nervous people fear what evidence may reveal. Irritated people dislike losing control of a narrative. Then she began directing her frustration toward the court. At first it was subtle. Small comments, dismissive gestures, occasional eye rolls, but I could feel the tension building. And in my experience, tension rarely disappears on its own. It escalates. What I did not know at that moment was that before the day ended, Karen would make a personal attack that stunned everyone in the courtroom. She would call the judge lazy. And when she did, a simple fact about my judicial career would leave her completely speechless. Because there are some mistakes people make only once, and Karen was about to make one of them. The second day of trial began with a noticeable shift in the courtroom. Not in the evidence, not in the legal arguments. In Karen Dawson herself, the confidence she displayed on the first day had grown stronger. That may sound strange, considering the defense had already introduced records contradicting portions of her testimony, but some people become more confident when challenged. Not because the challenge strengthens their position, because admitting uncertainty feels impossible. Years on the bench teach you that there is a significant difference between confidence and credibility. Karen possessed an abundance of the first. The second was becoming more difficult to establish. As proceedings resumed, Michael Turner's attorney continued presenting project documentation. The records were remarkably detailed. Every change request, every revised estimate, every scheduling adjustment, every approval signature. The level of organization impressed even me. Construction disputes often become difficult because memories fade and expectations evolve. Docs can solve that problem. Docs remember. Karen, however, appeared increasingly frustrated by the existence of those documents. Each new exhibit seemed to create another obstacle for her narrative. And the jury was noticing. I watched them carefully. That is one of the most important responsibilities of a judge. Jurors communicate constantly without speaking. Their posture changes. Their attention shifts. Their expressions reveal curiosity, skepticism, confusion, and sometimes disbelief. Several jurors had begun comparing Karen's testimony directly against the records appearing on the screen. That development mattered a great deal. Then Michael Turner took the stand. He was not a polished speaker. He occasionally paused while recalling dates. He checked records to verify details. He corrected himself when uncertain. Ironically, those imperfections often increase credibility. Truthful people rarely remember every detail perfectly. Prepared stories often sound far smoother. Michael described months of project modifications requested by Karen, expanded work orders, additional materials, repeated design revisions. As he spoke, photographs were displayed showing the evolution of the renovation. The timeline supported his account. Karen grew visibly impatient. She interrupted twice, then 3 times, then 4. Each interruption required a reminder regarding courtroom procedure. Years of experience have taught me that people reveal themselves most clearly when rules prevent them from controlling a conversation. Karen did not like losing control. That much was becoming obvious. Then came an email exchange that changed the atmosphere entirely. The defense introduced correspondence between Karen and Michael during the renovation. One message immediately captured everyone's attention. In it, Karen approved a major modification to the kitchen layout. The modification added nearly 3 weeks to the construction timeline. The email was clear, direct, unambiguous. Yet earlier testimony suggested she had never authorized the delay. The contradiction hung in the air. Jurors noticed. I noticed. Karen noticed. That last observation proved particularly important because from that moment forward, her frustration stopped focusing on Michael Turner. Instead, it began drifting toward the court itself, toward procedure, toward rulings, toward me. I have presided over enough trials to recognize the warning signs. When evidence becomes difficult to challenge, some litigants begin challenging the process. It is a psychological shift, a dangerous one. And Karen was moving steadily in that direction. Then, shortly before the afternoon recess, she muttered something loud enough for several people to hear. Not loud enough to interrupt proceedings, but loud enough to attract attention. The jurors looked up immediately. So did the attorneys. The comment was brief, dismissive, and directed squarely at the bench. At that moment, I realized Karen's growing frustration was about to become something far more serious, because by the next morning, she would stop criticizing the evidence. She would stop criticizing the defense. And she would make a personal attack against the judge himself, an attack she believed would embarrass the court. Instead, it would trigger a response that nobody in that courtroom would ever forget. The third day of trial began with a tension that everyone in the courtroom could feel. The previous afternoon's comment had not been forgotten, neither by the attorneys nor by the jury, and certainly not by Karen Dawson. I noticed her immediately when she entered. She appeared determined, almost defiant. The confidence remained, but now it was mixed with something else, resentment. Years on the bench have taught me that resentment often appears when reality refuses to cooperate with someone's expectations. Karen had entered this lawsuit expecting a straightforward victory. Instead, she found herself confronting contracts, emails, approvals, and records that repeatedly contradicted key portions of her claims. That frustration was beginning to show. As proceedings resumed, Michael Turner's attorney introduced another series of exhibits, project timelines, vendor invoices, material delivery records. Nothing dramatic, nothing sensational, just facts. But facts have a remarkable way of accumulating. Each document alone seemed small. Together, they formed a picture. And that picture was becoming increasingly difficult for Karen to explain away. Then came testimony from an independent building inspector. His involvement had started months before the lawsuit. He had visited the property after Karen complained about construction quality. The inspector's report was detailed, professional, and largely favorable to Michael Turner. Minor issues had been identified. Those issues had been corrected. The renovation met applicable standards. The jury listened carefully. Karen did not. She frequently shook her head, rolled her eyes, whispered comments under her breath. The behavior was impossible to ignore. At one point, I reminded her to refrain from interrupting testimony. She nodded, then immediately sighed loudly enough for half the room to hear. The inspector continued. The evidence continued, and the pressure continued building. I could see it. People often imagine courtroom drama as sudden explosions. The reality is usually different. Pressure builds slowly, then one moment becomes the spark. That spark arrived shortly after lunch. Michael's attorney displayed a timeline comparing Karen's claims against documented events. The visual was effective. Several contradictions became immediately obvious. One date conflicted with an email, another conflicted with an invoice. A third conflicted with a signed approval form. The jury studied the timeline closely. Karen did not like that. Not at all. She raised her hand repeatedly, attempted to interject to correct permission to explain. The more the timeline remained on the screen, the more frustrated she became. Then she stood, without permission. Again, the courtroom fell silent. I instructed her to sit. Instead, she began speaking. At first, her comments focused on the evidence, then the attorney, then the process. And finally, the court itself. The shift happened so quickly that several people seemed surprised by it. Karen claimed the court was overlooking important details. She claimed everyone was giving Michael Turner the benefit of the doubt. Then she said something that immediately changed the atmosphere. She looked directly toward the bench, directly at me, and questioned whether I had even reviewed the evidence carefully. The gallery became quiet. The jurors stopped writing. Court staff looked up. Years of experience have taught me that personal attacks rarely strengthen legal arguments. Usually, they reveal frustration, and frustration was now driving Karen's decisions. I remained calm. That is part of the job. Emotion from the bench solves nothing. But as I watched her continue speaking, I realized something important. Karen no longer viewed the courtroom as a place to resolve a dispute. She viewed it as an obstacle standing between her and the outcome she wanted. And that mindset was about to lead her into a catastrophic mistake. Because within hours, she would abandon criticism altogether and launch a direct insult at the judge. An insult so arrogant that the entire courtroom would freeze. And when I finally responded, a single fact about my judicial career would completely destroy the narrative she had spent days trying to build. The fourth day of trial is the day I remember most clearly, not because of the evidence, not because of the verdict. Because it was the day Karen Dawson stopped hiding her frustration. By that point, the case had developed a rhythm. The defense introduced records. Witnesses confirmed timelines. Documents supported testimony. And each time the evidence contradicted Karen's version of events, her patience seemed to shrink. I watched her closely that morning. Years on the bench teach you that people often signal their intentions long before they act. Karen's body language had changed. Her responses had become sharper, her interruptions more frequent, her expressions more dismissive. The jury noticed it too. One of the realities of trial work is that jurors observe everything. Not just testimony, behavior, attitude, reactions, the way people conduct themselves when things stop going their way. As proceedings continued, Michael Turner's attorney introduced yet another series of project communications.dest messages. Approval emails, scheduling discussions, nothing dramatic, nothing explosive, just consistent evidence. And consistency can be incredibly powerful. Karen, however, appeared increasingly irritated by it. At one point, she laughed dismissively during testimony. At another, she shook her head while a witness was answering questions. Twice I reminded her to allow the proceedings to continue without interruption. Twice she complied, but only briefly. The pressure was building. Everyone could feel it. Then came the moment that changed everything. Michael's attorney displayed a summary chart comparing the original renovation agreement against the dozens of modifications Karen had personally requested. The chart was devastating, not because it contained accusations, because it contained signatures, dates, approvals, records facts. As the jury reviewed the information, I noticed several members studying the chart with unusual attention. Karen noticed too, and that was when she lost her composure. She stood abruptly. The movement startled several people in the gallery. I instructed her to sit. She remained standing. For a moment, nobody spoke. The courtroom seemed to hold its breath. Then Karen looked directly toward the bench. I remember the expression clearly. Not anger, contempt. Years of experience have taught me to distinguish between the two. And what came next stunned the room. She pointed toward the evidence screen, then toward me, and said, "Maybe if this court wasn't so lazy, someone would actually look at the whole picture." Silence. Doblitzel silence. Even now, I can remember how still the room became. Jurors stopped writing. The attorneys froze. The court reporter looked up. For several seconds, nobody moved. Karen appeared convinced she had made a powerful point. That observation fascinated me, because people sometimes mistake boldness for effectiveness. They are not the same thing. I remained completely calm. A judge's authority does not come from volume. It comes from discipline. So I simply looked at her and waited. Silence can be remarkably uncomfortable, especially for people expecting an argument. Karen shifted slightly. The confidence remained, but I could see uncertainty beginning to emerge. She had expected resistance, perhaps outrage. Instead, she received neither. Then I asked a simple question. "Mrs. Dawson, are you suggesting this court has not reviewed the evidence?" The question seemed to catch her off guard. She hesitated, only briefly, but long enough, because she was now standing at the edge of a mistake she could not undo. And what she did not know was that her insult had created the perfect opportunity for a response that would change the entire atmosphere of the trial. A response rooted in one fact, one number, one extraordinary detail from my judicial career. And when I finally revealed it, Karen would have absolutely nothing left to say. The silence after Karen Dawson called the court lazy was unlike anything I had experienced in months, not because the insult itself was particularly creative. It was not. Not because judges are immune from criticism. We are not. The silence came from the realization that she had crossed a line she did not fully understand. The entire courtroom waited. Jurors, attorneys, spectators. Court staff. Everyone was watching the bench. Everyone was waiting for my response. Karen stood there confidently, at least at first. She seemed convinced she had exposed some weakness in the proceedings. That belief would not survive the next few minutes. Years on the bench have taught me that emotional responses rarely improve difficult situations, so I remained calm, completely calm. I looked down briefly at the case file, then back toward Karen. Then I asked another simple question. Ems. Dawson, how many cases do you believe I have decided during my judicial career? The courtroom became even quieter. Karen looked confused. Several jurors exchanged curious glances. The attorneys appeared uncertain where the conversation was heading. That was understandable. Karen hesitated, then shrugged. I don't know. An honest answer, perhaps the most honest answer she had given all week. I nodded, then I spoke. More than 25,000. The room froze, not metaphorically, actually froze. I watched the reaction spread across the courtroom. Several jurors looked at me, then at Karen, then back again. One spectator's eyebrows shot upward. Even Michael Turner seemed surprised. Karen blinked once. Twice, the confidence that had carried her through the trial suddenly wavered. Years of experience create perspective. That was the point I wanted her to understand, not authority. Perspective, I continued. More than 25,000 disputes, contract cases, property cases, construction cases, business cases, family conflicts, civil claims. The silence remained absolute. Nobody interrupted. Nobody moved. I could see Karen listening now, really listening, perhaps for the first time. Then I added the statement that would become the defining moment of the entire trial. Do you know what 25,000 cases teach a judge? Karen said nothing. The jury leaned forward. The room waited. They teach you that evidence matters more than confidence. The words hung in the air, Sybil direct, impossible to misunderstand. Then I gestured toward the exhibits displayed throughout the trial. The contracts, the emails, the approvals, the photographs, the records. Those documents don't care who sounds persuasive. They don't care who speaks the loudest. They don't care who becomes frustrated. They only care about being accurate. Karen looked down for the first time since the trial began. She looked down. Years of courtroom experience have taught me that moments like this rarely occur because of a brilliant argument. They occur when reality becomes impossible to avoid. And reality was standing in front of her, after page, exhibit after exhibit, contradiction after contradiction, then I delivered one final observation. Experience does not make a judge infallible. But 25,000 cases teach you how to recognize when evidence and testimony stop matching. The effect was immediate. Karen had no response, no interruption, no accusation, no comeback, nothing. The woman who had dominated every conversation for days sat down quietly. The jurors noticed, everyone noticed. Because something fundamental had changed, the trial was no longer about whether Karen could control the narrative. The narrative was gone. Only facts remained. And as I looked toward the jury, I realized they had already begun reaching conclusions of their own. The most important decision was still ahead. Because soon the jury would decide whether Karen's claims survived scrutiny or whether her own conduct throughout the trial had become the strongest evidence against her. The final day of the trial arrived with a sense of inevitability. That does not happen often. Most cases remain uncertain until the very end. Evidence can be interpreted differently. Witnesses can be viewed differently. Reasonable people can disagree. But this case had gradually transformed into something else. A lesson in credibility, a lesson in humility, and perhaps most importantly, a lesson in the difference between confidence and proof. As the courtroom filled for the final time, I noticed a remarkable change in Karen Dawson. The woman who had interrupted witnesses, challenged procedures, and insulted the court sat quietly at her table. No dramatic gestures, no dismissive laughter, no commentary. The contrast was impossible to miss. Michael Turner appeared different as well, still nervous, still cautious, but noticeably relieved. The burden he had carried throughout the litigation seemed lighter, because by now, most of the relevant facts had been placed before the jury. The attorneys delivered closing arguments. Michael's attorney focused almost entirely on documentation, contracts, Gans signed approvals, Chamption requests, inspection reports. The evidence spoke with consistency. And consistency is often persuasive. Karen delivered her own closing argument afterward. She remained passionate, determined, at times emotional. She argued that she had been treated unfairly, that she felt overwhelmed by the process, that mistakes had occurred. Some of those feelings may have been genuine, but feelings alone cannot overcome records. That principle lies at the heart of many courtroom decisions. Then the case went to the jury. The wait felt long. It always does. No matter how many trials a judge oversees, the period between deliberation and verdict never becomes routine. Eventually, the clerk informed us that a decision had been reached. The courtroom filled again. Everyone returned to their seats. The atmosphere was tense. Karen stared straight ahead. Michael clasped his hands together. The foreperson stood. The verdict form was opened. The room became silent. Then the decision was read. The jury found in favor of Michael Turner. Karen's claims were rejected. The jurors concluded that the evidence supported the defense's account of the renovation project, and that the delays, costs, and modifications had largely resulted from decisions Karen herself had approved. As the verdict echoed through the courtroom, I watched both parties carefully. Michael closed his eyes briefly. The relief was obvious. Months of uncertainty had finally ended. Karen remained motionless. No outburst, no accusation, no dramatic declaration. Just silence. Sometimes silence is acceptance. Sometimes it is reflection. Only the person experiencing it truly knows which. After the jury was dismissed, I offered a few final remarks before closing the case. I explained that courts are not designed to reward confidence. They are designed to evaluate evidence. A person may speak eloquently and still be mistaken. A person may appear nervous and still be correct. That distinction matters because justice depends upon facts rather than appearances. Then I addressed something that had clearly remained on everyone's mind, Karen's comment, the accusation that the court was lazy. I explained that judicial experience is not about prestige, it is about exposure. 25,000 cases do not make a judge perfect. Nothing can, but they teach patterns. Human behavior, credibility, the countless ways evidence either supports a story or contradicts it. The courtroom gradually emptied. Jurors left. Attorneys packed their files. Court staff completed their final tasks. Eventually, the room became quiet. As I gathered my papers, I found myself reflecting on the moment Karen called the court lazy, not because the insult mattered. It did not. What mattered was the assumption behind it. She believed confidence could overcome documentation. That conviction could outweigh records. That certainty could replace proof. The jury reminded everyone otherwise. And that is why I still remember the case, because it demonstrated a truth that extends far beyond any courtroom. Experience is valuable. Confidence is useful, but neither is a substitute for facts. When evidence speaks clearly enough, it does not matter who talks the loudest. The truth eventually becomes impossible to ignore. And after more than 25,000 decided cases, that remains one lesson I have never seen fail.